So think about the land under your feet right now. Like, you might have a deed tucked away in a safe, and you pay your property taxes every year.
But in the eyes of the law, you're essentially just a guest, at least until you can prove the state actually invited you to own it.
Right, which is exactly the Regalian Doctrine in a nutshell. It's this foundational idea that all land belongs to the state unless it's been officially declared private.
Exactly.
So today we are jumping into this exploration into our source material on Philippine land registration and the Torrens system. We really want to unpack how land moves from the public domain to your hands.
And you know how the state can take it right back.
Yeah, which is the scary part. Because this whole system is built on a very strict hierarchy of power.
It really is. And a huge part of that is the non-delegation rule. In Latin, it's delegata potestas non potest delegare.
Meaning you can't delegate a power that was already delegated to you.
Spot on. Practically speaking, this means only the president and the DENR secretary have the authority to actually classify land.
So if a local official says a plot is private,
it means absolutely nothing if the president hasn't signed off on it. The paper trail is incredibly short and kept right at the top.
Which brings us to the no-go zones, the places you can simply never own.
Right, like navigable waters, riverbeds, public highways, those are always off limits.
But there is a trap here that the material calls the forest myth.
Oh yes, the forest myth. This catches so many people off guard. You might see a flat, dusty field with 0 trees in sight and just assume it's agricultural land ready for a title.
Because it looks like a farm.
Right. But legally, the physical appearance is totally irrelevant. If the state hasn't formally reclassified it, that dusty field is still officially forest land.
I mean, the law just assumes all unclassified land is public forest by default.
Exactly. It stays that way until the executive branch officially labels it alienable and disposable, or A&D.
I always found that term disposable kind of funny. Like, doesn't mean it's trash.
No, not at all. It just means the state is legally allowed to dispose of its ownership and let a private citizen take over.
But even then, nature can mess with the borders. Like, what happens with accretion when your land literally grows because of shifting water?
Well, the rules there depend entirely on the water's edge. If you live on a lake and the soil builds up, creating lake bank, that new land belongs to you.
The adjacent owner.
Yes. But if you're on the coast and the sea bank grows, that belongs to the public domain. The logic is that the coastline is a vital public resource.
So the state keeps control even if it grows right onto your property line. Okay, so once the land is classified and borders are set, we enter the Torrens system.
The administrative side.
Right. But what if the system fails and 2 people get a title for the exact same plot?
In the Torrens system, time is the only currency that matters. The rule of successive registration says the earlier date always prevails. Period.
Always the earlier date.
Yes. If a court accidentally issues a second decree for land that's already registered, that second title is just null and void. The court literally loses jurisdiction the moment the first title is finalized.
That puts a massive burden on the buyer. But there is this middle ground called patrimonial property.
Right. That is the only time state land acts like private land. Think of it as land the state has officially retired from public service.
So there has to be an express declaration that it's no longer needed for public use.
Exactly. Only then can it be subject to prescription, where you could maybe claim ownership based on long-term possession. Without that retirement declaration, you could live there for a century and have no legal claim.
Which leads to the part that will make property owners sweat. Reversion, the state's power to basically hit the undo button on a title.
Yes, reversion proceedings. If a title was acquired through fraud, the state's right to take it back is imprescriptible.
Meaning it never expires. No statute of limitations.
None. The state can come back 50 or 100 years later. Usually it's the Solicitor General who files for this after a DENR investigation.
That makes a title feel less like a final guarantee and more like a permanent pending status.
Yeah.
Is there any protection if you bought the land not knowing the original title was a lie?
You can argue you're an innocent purchaser for value. If you bought it in good faith, the court might protect you.
But the burden of proof is on you.
Yes, and if the land was never alienable and disposable to begin with, even being innocent might not save your investment.
It really hammers home that a title is only as good as the state's original classification. So here's a final thought to mull over. If the state's right to reclaim land stolen via fraud never expires, how permanent is your ownership in a system where a mistake made a century ago could suddenly become your problem today? Thanks for joining this exploration into the source material with us. See you next time.
You know, that piece of paper you have, your land title, it feels like the ultimate proof of ownership, right? Solid gold. But here in the Philippines, the real story of who owns the ground beneath our feet, well, it's a lot more complicated. Today, we're going to dig into the fundamental rules of land ownership that might just change how you see that title forever.
So let's just jump right in with the big question. You've got a certificate of title, it's got your name on it, it looks official, you'd think that means it's yours, end of story. But what if I told you that paper might not be the absolute final word? That's exactly what we're going to unpack.
All right, to make sense of all this, we've got a simple roadmap. First, we'll cover the biggest rule of all, why the state is the original owner of everything. Then we'll get into the lands you can never own. After that, we'll tackle what happens when two people have a title for the same land, how the government can actually take back property, and finally, the one true path for public land to become private.
Okay, let's start with the foundation. This is the single most important concept you need to grasp. Once you get this, everything else we talk about is going to click into place.
Here it is, the golden rule. You have to think of the state as the original source, the fountainhead from which all land ownership flows. Every single private title out there started as a grant from the state. And if a piece of land can't be proven to be private, the law's default setting is that it's public property, owned by the state for everybody.
Now, this whole idea has a formal legal name, the Regalian Doctrine. It's really the cornerstone of Philippine land law. It's what gives the government both the power and the duty to manage the country's natural resources for the benefit of all of us.
So, who gets to decide if a patch of land is for farming or if it needs to stay a forest? Well, there's a strict chain of command. Congress sets the general rules, but it's the executive branch, think the president or the DNR, that actually gets to classify the land. And here's the part you really need to remember. Courts can't do this. A judge has zero power to reclassify land. That power belongs only to the executive.
And that idea leads us straight to our next point. I mean, if the state owns everything to begin with, it just makes sense that there are certain types of land it will never, ever let go of. So here's the off-limits list. You can never privately own any of these. And here's the real kicker. Let's say by some crazy mistake, your official land title actually includes a public highway or a stretch of beach. That part of your title is totally, completely useless. It's void. The paper doesn't change reality. That land is still public property, period. And check this out. This shows you just how serious the law is about this. You could be looking at a piece of land that is completely barren, not a single tree in sight, and you'd think, oh, that's obviously farmland. But if its official classification is forest land, then legally, it's still forest land. Its status is decided by law, not by what it looks like today.
Okay, let's wade into what has to be one of the most stressful situations in all of real estate. What happens when two different people are holding what look like perfectly valid titles for the exact same piece of property? How on earth does the law sort that mess out?
Let's just paint a simple picture. You've got person A who got their title way back in 1995. Then a decade later, person B gets a title for the very same land. Both titles look legit, both are registered. So who wins? You know, the rule here is actually refreshingly simple. First in time, first in right. The earlier title always wins. Once a piece of land is registered under our official system, a court just doesn't have the power to register it again for someone else. That means the 2005 title, it was basically null and void from the very second it was issued. The owner is, without a doubt, the person with the 1995 title.
So we've seen how the system fixes issues between two people. But what happens when the problem is bigger, like when a title was issued through fraud or for public land that should never have been made private to begin with? This is where the state's ultimate power comes in. It's called reversion.
This quote really says it all. The key word here is imprescriptible. That's a fancy legal term that basically means there's no time limit. The state's right to take back public land that was wrongly titled never expires. They can start the process today or 50 years from now. So when does the government pull this trigger? Usually it's because of fraud or a huge mistake, like a title that accidentally includes a river. But, and this is a really important but for buyers, there's an exception. If that property was sold to an innocent purchaser for value, someone who did their due diligence, paid good money, and had no idea there was a problem, the government generally can't take the land back from them.
And look, this isn't some random action. It's a very formal legal process. First, the DNR does the legwork. They investigate, find the evidence. But only one office in the entire country can actually file the lawsuit to get the land back. The Office of the Solicitor General, who acts as the lawyer for the Philippines itself.
Okay, so we've spent a lot of time on what you can't do and how the state protects its land. But is there a way for public land to legally become private? The answer is yes, but the path to get there is very, very specific.
You need to know these magic words. Patrimonial property. This is the key legal status change. For a piece of public land to even have a chance at being privately owned, it first has to be converted into the state's patrimonial property. Think of it as property the government owns in a private capacity, not for public use.
So how does that happen? It's a strict two-step process. First, the land has to be officially classified as alienable and disposable. That just means it's eligible to be sold. But, and this is the part everyone forgets, that is not enough. The government then has to issue a second, totally separate, explicit declaration saying that land is no longer needed for any public purpose. Only when both of those steps are done does the door to private ownership finally crack open.
So once land becomes patrimonial, and only then, can a person claim it through what's called prescription, which is just gaining ownership through long-term open possession. There are two ways to do it. Occupy the land for 10 years in good faith with a document you honestly believe is a real title. Or you can occupy it for 30 years straight, even if you don't have a title. But the most important part? That 10 or 30-year clock doesn't even start ticking until the government has finished its two-step conversion.
So after all that, what's the big takeaway? What's the bottom line? It's that private land ownership isn't some absolute God-given right. In the Philippines, it's a privilege that flows directly from the state. The whole system is built on this idea that we have to protect our public lands, our country's natural heritage, for the good of everyone.
And that kind of leaves us with one final massive question to think about. This system is clearly designed to protect our shared resources, but at the same time, it creates real challenges for individuals who just want the security of owning their own piece of land. So the ongoing struggle is finding that perfect balance, protecting the public good for future generations while still respecting that very human dream of private ownership. It's a balance we all have a stake in.
Welcome back to the deep dive. You know, I was driving past this massive construction site the other day. Yeah, fences up, cranes everywhere, the whole deal. And I saw that classic sign, you know, the one, private property, no trespassing.
The big, bold letters.
Exactly. And it just got me thinking about the absolute, the confidence of that sign. It's a real declaration. It basically says, I own this square of the earth, and I have the piece of paper to prove it.
It is the ultimate assertion of control, isn't it? I mean, we really tend to view land ownership as the absolute bedrock of stability.
Yeah.
You buy it, you title it, it's yours. End of story.
Exactly. It feels permanent. But the stack of documents we were wading through today, which, by the way, for you listening, are these incredibly dense pre-bar review materials on Philippine land law and the Torrens system.
Very dense.
Yeah, very. But they suggest that our confidence might be a little misplaced because it turns out the private property sign is actually hanging by a very thin, very invisible thread.
A thread held by a very powerful hand, actually.
Right. And that is what we are unpacking today for you. We're looking at the illusion of absolute ownership. We're going to find out why a title, even a completely legitimate one, might be totally worthless if the land underneath it has a secret identity.
A hidden legal status, yeah.
Yeah, we're talking about the untouchables, the invisible strings, and the, frankly, terrifying power of the state to just take it back.
And to really understand that terror, or at least that, precariousness, we have to start with the factory setting of all land in the Philippines.
This is the concept that just blew my mind when I first read through the prep notes. The Regalian Doctrine. Even the name sounds heavy. It sounds like something straight out of Game of Thrones.
It effectively is. I mean, it is entirely feudal in its roots. The term comes from regalia, which refers to the royal rights of the king. So in the Spanish conquest era, the king of Spain theoretically owned everything he, quote-unquote, discovered.
Which is really just a nice way of saying content.
Yeah, precisely. But that concept, it actually survived the revolution, it survived the American occupation, and it is firmly embedded in the 1987 Constitution. The Regalian Doctrine states that all lands of the public domain belong to the state. The state is the ultimate source of any asserted right to ownership of land.
Let's just pause on that for a second because the implication there is massive.
Yeah.
If I'm standing in the middle of a random field,
right,
and there's no fence, no sign, no clear owner, the default assumption isn't finders keepers.
No, absolutely not. The default assumption is that the state owns it.
It's guilty until proven innocent, but for dirt.
That is a very colorful way to put it, but yes, all lands not appearing to be clearly within private ownership are legally presumed to belong to the state.
Wow.
So unless a title clearly shows private ownership, or unless the state has explicitly said, hey, we're releasing this specific plot to you, it remains part of the inalienable public domain.
Inalienable. We're going to use that word a lot today, I feel like.
We definitely are. It basically means it cannot be alienated. It cannot be sold, transferred, or owned by a private person. It's totally off the market.
So our mission for this deep dive is to trace that invisible string. We need to figure out, for you listening, who decides when land stops being the king's and starts being yours. Because as we'll see, it is not always the person you'd expect.
We're going to look at the power of classification, the lands that can never be owned no matter what some shady broker tells you, and the absolute nightmares that happen when titles collide.
Okay, let's jump into section 1, the power of classification. This is where rubber meets the road, or I guess where the plow meets the field.
Classification is really the first major hurdle. Before land can be owned by anyone, it has to be legally classified as alienable and disposable.
Okay, so let's paint a picture here.
Yeah.
Let's say I have a client, we'll call him Juan. Juan has been living on a piece of land in the province for 30 years. He grows corn, he raises chickens, he built a house. It looks like a farm, it smells like a farm. So Juan goes to court to get his title confirmed. He brings photos, he brings soil samples, he even brings the barangay captain to testify. He says to the judge, look at this. It is clearly agricultural land.
That is a very, very common scenario.
So the question is, can the judge look at that overwhelming pile of evidence and say, I agree, the evidence shows this is agricultural land, I decree it to be so?
You would certainly think so. We're all trained to believe that courts are the ultimate finders of fact. If the facts scream farm, the judgment should say farm.
Right.
But in Philippine land law, the answer is a hard no. The courts actually do not have the power to determine the classification of lands of the public domain.
That seems so incredibly counterintuitive. If the judge is the arbiter of truth, why are they basically blindfolded here?
It isn't about blindness, it's about jurisdiction. The classification of land deciding whether it's forest, mineral, or agricultural is strictly an executive function. It belongs to the office of the president, or by delegation, the Department of Environment and Natural Resources, the DENR.
So Juan can bring all the corn stalks he wants into the courtroom, but if the president hasn't signed a piece of paper saying this is farmland, the judge just can't help him.
Correct. And this relies on a legal maxim that I think really explains the whole architecture of the government here. Delegata potestas non potest delegari.
Okay, you have to walk us through that one.
Sure. It translates to what has once been delegated by Congress can no longer be further delegated.
So it's about the chain of command.
Exactly. The state, as the ultimate owner, acts through the legislature. So Congress passed laws, specifically Act No. 2874 and Commonwealth Act No. 141. These are basically the grandfathers of modern land law.
Right.
And in those laws, Congress said, we are giving the power to classify public lands specifically to the executive branch.
They gave the job to the president.
Yes. And because Congress gave it strictly to the executive cannot just pass the buck to the courts. And more importantly, the courts cannot usurp that power. It's a fundamental separation of powers issue. If a judge were to look at Juan's farm and say, I classify this as agricultural, that judge is effectively rewriting the law.
That is such a crucial distinction for you to keep in mind. The judge can decide who owns the land, but only the president can decide what the land is.
Precisely. And this wasn't always the strict interpretation. If you look back at the history, there were older cases like Ancrin and Ramos where the courts were a little bit more loose with it.
How so?
Well, they used what they called a presumption of agricultural nature. Basically, if it looked like a duck and quacked like a duck.
They called it a farm.
Right. But that presumption has been totally set aside in modern jurisprudence. The Regalian Doctrine has really tightened its grip over the decades. Now, the rule is very simple. Silence means state ownership.
So the burden of proof is entirely 100% on Juan.
100%. Juan needs to show up to court not just with his corn, but with a certification from the DENR or a proclamation from the president that explicitly says this specific tract of land has been reclassified as alienable and disposable.
And without that paper?
Without that paper, the legal presumption remains that it is part of the inalienable public domain.
And if it's public domain, Juan is just a squatter.
Effectively, yes. No matter how long he has been there.
Man, that is tough. But it leads us directly into the scariest part of this deep dive, the untouchables. We just established that you need the government to say, yes, this is sellable. But there are categories of land where the government says no, never, absolutely not.
These are the non-registerable lands, and this is really where people get burned. You might have a title, you might have paid millions of pesos for it, but if your land falls into one of these specific categories, your title is just really expensive wallpaper.
Let's start with the one that feels the most like a trap.
Forests.
Forests and timberlands.
Now, when I hear forest, I naturally think of trees. I think of the Amazon. I think of heavy canopy cover. So if I'm a developer and I am looking at a piece of land that is just dirt, maybe some scrub, a few bushes, I'm thinking, great, not a forest. I can build here. And that is what we call the visual test. And relying on the visual test is the absolute fastest way to lose your investment.
Because the legal definition of forest has nothing to do with actual trees.
It sounds absurd, but yes. Legally speaking, forest land or timberland is a classification, not a physical description. Even if the land is completely stripped of its forest cover, even if it's a totally barren wasteland, it does not lose its legal character as a public forest.
Wait, play that out for a second. So I can have a plot of land that looks like a literal desert, but the law still treats it like a jungle.
Yes. The Supreme Court has been very, very explicit on this point. They ruled that the argument that only lands with trees should be considered forests simply fails.
Why? That just seems so illogical.
It's all about incentives. Think about it. If the law said it is only a forest if there are trees on it, what would a greedy developer do?
Oh, they would just burn the trees down?
Exactly. They would chop everything down, clear the land entirely, and then run to the judge and say, look, no trees. It's agricultural now? The law is structured to prevent that scorched earth strategy. The classification remains legally binding until the executive branch explicitly changes it.
So once a forest, always a forest, until the president says otherwise.
Correct. And here's the real kicker with this. Possession of forest lands, no matter how long, cannot ripen into private ownership.
Cannot ripen. That's a very specific legal phrase. It means the passage of time doesn't matter at all.
It completely stops the clock. You could have your family living on a patch of classified forest land since the Spanish colonial era, but if it was never legally reclassified, you don't own it.
There's a famous case about this in the source materials, the Mount Banahaw case. Can we walk through that? Because I think it really illustrates the human tragedy of this doctrine.
The Mount Banahaw San Cristobal National Park case. This is a classic example. So historically, this entire area was proclaimed as a forest reserve way back in 1921.
1921. So that's during the American era.
Right. And then later, in 1941, it was established as a national park. Now, fast forward decades later, you have people actively claiming parts of this land. They likely lived there for generations, worked the land, maybe even bought rights from someone else.
Yeah.
And they eventually go to court to register it under their names.
And what did the court say to them?
The court simply looked at the timeline. 1921 proclamation, 1941 proclamation. Was there ever a document officially releasing this land from that reservation? No. So the ruling was absolute. Forest lands or forest reserves are simply not capable of private appropriation.
Even if the specific spot they were claiming didn't have a single tree on it.
Totally irrelevant. The classification covers the coordinates on a map, not the vegetation on the ground. Unless the Director of Forestry or the DENR reclassifies it as alienable and disposable, it is strictly off limits.
It really reinforces that idea that the state operates on a map, not on the ground.
That is a really great way to put it. The state looks at the decree while the squatter looks at the dirt. The decree wins every single time.
Let's move to another untouchable category that I found fascinating. Military reservations.
This one is highly relevant right now because of how rapidly our cities are expanding. We have the perfect case study with Fort Andres Bonifacio,
Which we all know today as BGC. Bonifacio Global City. High-end malls, luxury condos, corporate headquarters everywhere.
But underneath all that glitz is a very strict military history. Fort Bonifacio was a massive military reservation. And the strict rule here is that lands inside a military reservation are inalienable. They cannot be the object of cadastral proceedings.
Cadastral proceedings, meaning the formal survey and titling process.
Right. You absolutely cannot drag a piece of a military base into a court and try to register it as your own.
But wait, BGC is private now. I can go buy a condo there tomorrow.
True, but that's because the government went through the proper process. They passed a specific law, the BCDA law. They officially reclassified the land. They declared it alienable and disposable, and then they sold it. The state initiated and controlled that transfer.
I see. But if I tried to do that on my own, Say I found a sleepy corner of an active base that wasn't being used, and I built a house there. I could never title it.
Never. It remains completely off limits until the government explicitly releases it from the reservation zone. You cannot force the government's hand simply by occupying it.
It seems like the recurring theme here is the government acts, the individual reacts. You just cannot reverse that flow of power.
That is the absolute core of the Regalian Doctrine.
Okay, so we've covered the land. Now we really need to talk about water. Because if you think land law is tricky, water law seems downright slippery.
Water, shores, and reclamation. This is really where physics and law collide in interesting ways.
Let's start with rivers. We have a case study in the notes involving a Mr. Seosin, Republic v. Seosin. I want to tell his story because, honestly, I feel bad for the guy.
It is a very sympathetic case in many ways. You see, Seosin wasn't just some random squatter who built a shack. He actually had what's called a free patent.
Explain what that is for the listener.
A free patent is a formal grant of public land from the government. It's a completely legitimate path to ownership. He went through all the bureaucracy, he got the patent, and he registered it. He held a physical certificate of title issued by the Register of Deeds of Bulacan.
So he followed all the rules.
Right.
He has the official paper. It's a done deal.
He certainly thought it was done. But there was a massive flaw. The technical description of his land, the specific surveyed coordinates, accidentally included a portion of a branch of the Mequoian River.
A river branch. Was it a big river? Like noticeable?
It was a navigable stream or creek, and navigable is the key word there. It means it's usable for transport or commerce.
And what does the law actually say about navigable rivers?
They are completely outside the commerce of men. They are public domain. You cannot own a river, period.
So the government sued him to take it back.
Yes, the state filed an action for reversion, and Seosin's argument was exactly what you'd expect anyone to say. He said, I have a title. It is indefeasible. You, the government, gave this to me.
And normally, a Torrens title is indefeasible. It's supposed to be the final, unquestionable word on ownership.
Normally, yes, it is. But the Supreme Court ruled that his title was void ab initio, meaning void from the very beginning, specifically regarding that slice of the river.
Why? I mean, the government made the mistake. The surveyor or the clerk typed the wrong numbers.
Because the Constitution always trumps the Register of Deeds. The state simply cannot give away what it is legally forbidden to own in a private capacity. The river never stopped being public property just because a clerk made a typo on a title. So Seosin kept the rest of his dry land, but the portion covering the river was legally erased from his title.
That is wild. The river literally cuts right through the paper title.
It flows right through the legal fiction of it, yeah.
Okay, so that's rivers. What about the sea? The notes talk about foreshore land.
Foreshore land is that strip of land adjacent to the sea, which is alternately covered and left dry by the ordinary flow of the tides. Basically, the wet sand. Yes. And in Republic v. Kempin, the court reaffirmed the elementary rule here. Foreshore land is simply not capable of registration.
So I cannot own the beach in front of my luxury resort.
You cannot. If your title includes the foreshore or territorial waters, that specific part is void. The court can order reversion and just return it to the public domain.
But I see this all the time, though. Resorts building seawalls, people building fish ponds that extend way out into the water.
It definitely happens. People build fish ponds, they enclose the area, they try to claim it. But the Kumpan case tells us that the artificial conversion, like building that wall or the pond, doesn't change the legal status. If it was originally foreshore, it remains public domain.
So you are basically just renting time until the government knocks on your door.
Basically, yes. You're hoping they don't notice.
Now, here is the part that confused me initially, but I think it's really crucial for you listening. The difference between the sea and the lake. Because visually, water is water. But legally, the concept of accretion works entirely differently depending on what kind of water it is.
It's a fascinating distinction. Accretion is when soil is naturally and gradually deposited by the current, which adds new land to your property.
Right, so my property gets bigger for free, nature's gift.
Right. Now, listen to this legal distinction carefully. If this accretion happens on a seabank, meaning right next to the ocean, that newly formed land belongs strictly to the public domain.
The state takes it.
The state takes it. It is not yours. But if that exact same natural process happens on a lake bank like beside Laguna de Bay or a river bank, the accretion belongs to the owner of the adjacent private estate.
Wait, hold on. So if I live by the ocean, the new dirt is the government's. But if I live by the lake, the new dirt is mine. Why the double standard?
It goes all the way back to the Spanish law of waters. The concept is that the sea, the ocean, is a critical public asset for national defense, navigation, and large-scale commerce. The state jealously guards the coastline. Inland waters, like lakes and rivers, however, are treated more like neighbors adding soil to your yard.
So for our listeners looking for property, a lakefront investment has a built-in bonus, but an oceanfront investment has a strict cap.
Exactly. You won't gain any land on the oceanfront.
Let's talk about the biggest water-to-land issue of all, reclamation. We see this all over Manila Bay right now. They are literally building islands out of nothing.
Reclaimed lands. The source material cites 592.15 hectares of submerged areas in Manila Bay. That is a massive, massive amount of new real estate.
And who owns that new land the second it pops out of the water?
Initially, the state. It is considered sui generis, which means it's in a class of its own. It's an inalienable natural resource at that stage.
So I can't just go buy a plot of it.
Not easily and not immediately. The process to privatize reclaimed land is a very strict multi-step hurdle.
Walk us through it.
First, the Public Estates Authority, the PEA, has to actually reclaim the land physically. Second, the government must officially classify that new land as alienable and disposable.
Okay, so they give you the green light.
But that's not the end. The third step, and this is the one people always forget, the government must formally declare that the land is no longer needed for public service.
That third step just seems kind of redundant to me. If they already said it's disposable, why say it again?
Because it isn't redundant legally. Something can be classified as disposable, but still be actively needed for public service, like for a new government office building or a public plaza or a port facility.
Ah, I see.
Right. So until that final explicit declaration is made that it's no longer needed for public use, the land absolutely cannot be sold to a private corporation or an individual. It remains outside the commerce of men.
So all those gleaming new cities rising from the bay, they are navigating an absolute legal minefield to get those titles.
A very expensive and highly regulated minefield, yes.
All right, speaking of navigating minefields, let's talk about actual mines. Section 4, minerals and the indivisibility of land.
I love the potatoes versus gold scenario.
It really is the ultimate dream, isn't it? You buy a nice quiet farm, you are out there digging up potatoes for dinner, and you hit something hard with your shovel. It's a massive gold nugget.
I am rich. I retire immediately.
Well, you might be rich, but not because you own the gold. Under the Regalian Doctrine, the state owns all minerals, all of them, even if they are buried directly under your legally titled land.
This is that indivisibility of land concept mentioned in the notes.
Actually, it sort of challenges the indivisibility. The strict rule is that a single plot of land cannot be half agricultural and half mineral legally. It must be classified categorically as one or the other. It's binary.
So what happens to my potato farm when I find the gold?
This is where the sovereign prerogative comes in. Once minerals are discovered and mining claims are formally perfected by a company or the state, the land legally converts. The agricultural use is discontinued.
Wait. So my land forcefully stops being a farm and starts being a mine?
Legally speaking, yes. The shift in status happens once mining operations begin.
And do I at least own the mine?
No. You own the surface rights, but you absolutely do not own the minerals. And practically speaking, if the mining operation needs to dig up the surface of your farm to get to the minerals underneath, your surface rights are going to be secondary.
That feels like a massive violation of my property rights as a titled owner.
It can feel that way, but the Supreme Court has observed time and again that the mineral character takes precedence. The foundational theory is that the minerals are a national resource, intended for the development and benefit of the entire state, not just the lucky guy who happened to buy the farm above them.
So I just can't stop them. The bulldozers just roll in.
You can certainly demand just compensation for the damages to your property and your crops, but you cannot legally stop the extraction if the state has authorized it. Your title to the surface simply does not give you the right to extract or utilize the minerals, nor to block the state from doing so.
Man, it is a very sobering reminder that we really just live on the crust. The core belongs to the king.
That is the Regalian Doctrine in a nutshell.
Let's move to Section 5. We've talked about the clear-cut stuff. Forests, water, minerals. But what about the in-between lands? The unclassified lands?
This is the real danger zone for rural land buyers. We call it unclassified public land.
So it's not clearly proclaimed as a forest, but it's also not clearly stamped as a farm. It's just there. It's blank on the map.
Exactly. And if it is unclassified, the default setting immediately kicks in. It is legally presumed to be unregisterable. It is treated effectively the exact same as forest land.
So if I buy a tax declaration from someone for a piece of land that has no actual title, and it turns out to be unclassified on the government maps,
You basically bought air. The burden of proof is entirely on the applicant to prove the state released it. And possession alone, however long, is insufficient if it's unclassified.
and this brings us right to the concept of prescription. Squatters' rights. I feel like everyone knows a version of this in their head. Like if I live here long enough, uninterrupted, it eventually becomes mine.
That is called acquisitive prescription. And yes, it is a real legal concept, but it is so much harder to achieve than people think. It requires the land to be specifically patrimonial property.
Define that for us.
Patrimonial property is land that is owned by the state, but the state is effectively holding it in a private capacity, meaning it is not being used for public service like a school, and it's not for public use like a highway. It's basically the government's spare inventory.
Okay, so if the state just has some spare inventory sitting around, can I squat on it and eventually own it?
Yes, but here is the massive catch. The catch that destroys almost all of these claims in court. And this is outlined in the ruling of Heirs of Malabanan v. Republic,
Oh, this is a heavyweight case in the notes.
the heavyweight champion of land law. The court ruled that for land to be acquired by prescription, two things must happen. First, it obviously must be classified as alienable and disposable. But second, there must be an express government manifestation that the land is no longer needed for public service or the development of national wealth. Reference Civil Code Article 422 here.
That sounds exactly like the reclamation rule we just talked about.
It is very similar, but here is why it absolutely kills prescription claims in practice. The clock for your squatter's rights doesn't start ticking when you move in.
Right, when does it start?
The prescriptive period only begins after the government makes that express declaration that the land is patrimonial.
Oh, wow. Let's play that out for a second. Let's say I move onto a plot of public land in 1980. I build a house, I raise my kids there, and then in 2010, the government finally issues a paper declaring, hey, we don't need this land for public service anymore.
Your 30 years of living there from 1980 to 2010, they don't count.
They don't count at all.
Zero credit. Legally speaking, your possession for the purpose of acquiring the title only begins the day that declaration is signed in 2010.
That is brutal. That ruins families.
It is harsh, but the law is designed to strictly protect the state from losing its lands just because bureaucrats were slow to manage or classify it.
So, assuming the clock does actually start, say we are in 2010 and the declaration is made, how long do I have to wait to own it?
There are two types of prescription timelines. First is ordinary prescription that requires 10 years of possession. But you need to have good faith and just title.
Meaning
Meaning you honestly believe you have the right to own it, and you have some sort of paperwork or deed to back it up, even if that paperwork is technically flawed.
Okay, and the second time?
Extraordinary prescription. That requires 30 years of uninterrupted adverse possession.
30 years.
30 years. But the benefit of this route is that you don't need good faith. You can be a bad faith squatter knowing full well it's not yours. But if you hold it continuously for 30 years after it legally becomes patrimonial, it is finally yours.
That is literally a lifetime.
It is. It's a very, very high bar to clear.
Okay, we are in the home stretch here. Section 6, when titles collide. Because honestly, this is the stuff of real nightmares for property buyers.
Conflict resolution, and it happens far more often than you'd think in a paper-based system. Double registration.
Scenario for you. I buy a lot, I go through the motions, I get a Torrens title, it looks totally legit. But then you show up to my house, and you also have a Torrens title for the exact same plot of dirt.
The immovable object meets the unstoppable force. 2 pieces of paper, 1 piece of land. Who wins?
Yeah, who wins?
The absolute rule is prior in date, prior in right. The older title wins.
So we literally just look at the timestamp.
We look at the original registration date. This was firmly settled in cases like Gatyuan v. Gaypod and Realty Sales Enterprise v. IAC. The court held that the earlier certificate always prevails.
So if my title traces its roots back to a registration in 1980, and your title traces back to 1990.
I lose completely. My title, the 1991, is considered a void title.
But wait, I paid for it? I'm an innocent buyer. I didn't know someone else had it.
It doesn't matter to the land. The land belongs to the first registered owner. Your legal remedy, as the second buyer, is not to claim the land. Your remedy is to sue the person who sold you the bad title in the first place.
So I'm stuck chasing my money in court, but I still lost the home.
Exactly. The foundational logic is that once the land was fully registered in 1980, the Register of Deeds totally lost jurisdiction to ever register it again in 1990. Therefore, the Second Act was a legal nullity from the start.
Man. Now, what if the conflict isn't between two private citizens, but between a person and the state? We talked a bit about Sciosan and the river earlier. This brings up reversion.
Reversion proceedings, yes. The state's long arm.
It sounds like a clawback mechanism.
It is exactly that. It's a formal lawsuit filed by the state to cancel your title and literally take the land back into the public domain.
On what grounds can they just do that?
Usually it falls under fraudulent acquisition or oversight. Fraud means you actively lied or submitted fake documents to get the title. Oversight means the government made a gross error, like accidentally titling a navigable riverbed or a national forest.
Now, is there a statute of limitations on this? Can I say, hey, I've had this title for 50 years, leave me alone?
No. The state is never barred by time. The legal term is lashes. Lashes essentially means sleeping on your rights for too long. But lashes simply does not apply to the state when it is recovering lands of the public domain that were acquired via fraud or mistake.
Wait, so the state can wake up 50 years later, realize a surveyor made a mistake in the 1970s, and file a suit today?
Yes, it is an imprescriptible right. And typically only the Office of the Solicitor General, the OSG, can file these cases, usually based on evidence and recommendations from the Land Management Bureau, the LMB.
That is genuinely terrifying. Is there any defense at all?
There is one very narrow defense: the innocent purchaser for value.
Explain how that works.
Let's say the land was originally alienable and disposable, so it wasn't a forest or a river, just regular government land. And someone obtained a title to it through a fraudulent scheme.
Yeah.
But then that fraudster sold it to you, and you had absolutely no idea about the fraud. You checked the title, it looked clean, and you paid a fair market price for it. You are genuinely innocent.
Can the state still use reversion to take it from me?
Generally, no. In that specific scenario, the law steps in to protect the truly innocent buyer, because if they didn't, no one would ever trust the Torrens system.
Okay, so my innocence saves my house.
If, and this is a massive if you can prove it, the burden of proof shifts heavily to you. In reversion cases, the standard legal presumption of good faith isn't enough. You have to actively present evidence to the regional trial court to prove that you did exhaustive due diligence before buying.
And what if the land was a forest or a river to begin with, and not just regular land?
Then your innocence is completely irrelevant.
Really?
Yes. Because if it was non-registerable to begin with, the title was void ab initio. You cannot be an innocent purchaser of something that fundamentally cannot be sold in the first place. You lose the land, period.
Man, this has been intense, really intense.
It's a very heavy, complex topic.
We started this deep dive talking about the illusion of ownership.
Oh.
And I think we have definitely thoroughly shattered that illusion today.
Well, I hope we didn't just shatter it, but maybe replaced it with a much more realistic, grounded understanding of how land law actually works.
Let's recap the big takeaways for you listening. First, the judge is not the king. Only the executive branch, meaning the president or the DNR, can classify land.
Right.
Second, the visual test is a total trap. Just because there are no trees doesn't mean it's not a forest legally. The coordinates on the government map dictate the reality. Third, some things are simply untouchable. You cannot own a navigable river, a beach foreshore, or a military base, even if you hold a piece of paper that says you do. And fourth, the state plays the long game. Reversion can happen decades later, and older titles always beat newer titles.
That is a very solid, comprehensive summary.
So here is the final provocative thought I really want to leave you with today. We walk around every day thinking our home is our absolute castle. But after going through all this, I'm realizing that private property is really a bit of a legal fiction.
It is. We hold temporary rights. We don't hold absolute dominion.
Exactly. So if you are currently holding a title or you're looking to buy one soon, you really need to look at it and ask yourself, do I actually own this? Mm-hmm. Or am I just the current temporary caretaker of a piece of the public domain, just waiting for the Solicitor General to realize they want it back?
It is definitely a chilling thought, but it just heavily emphasizes the absolute importance of due diligence. You can't just look at the title. You have to look at the history. You have to look at the legal classification. You have to trace that string all the way back to the hand that holds it.
Great advice. Thank you so much for guiding us through this legal jungle today.
My pleasure. Anytime.
And to you listening, thanks for diving deep with us. Go check your titles. We'll see you next time.
Welcome to the debate. I want you to imagine a scenario. You have saved up for 20 years to buy a home. You find the perfect lot, you go to the Register of Deeds, you check the certificate of title, and it is pristine. It has the seal, the signature, the technical description. So you pay your millions, you build your house, and you raise your family. You sleep soundly because that piece of paper says owner next to your name. Then one morning, the government knocks on your door and tells you that your title is fake. Not because you forged it, and not because the seller scammed you, but because 50 years ago, a surveyor classified the soil incorrectly.
It sounds like a horror story, doesn't it? But in the landscape of Philippine law, this is a very real, very distinct possibility. We are staring down the barrel of a massive conflict today. On one side, you have the Torrens system, which promises that a certificate of title is indefeasible, unbreakable, basically the final word. On the other side, you have the Regalian Doctrine, the constitutional principle that the state owns all natural resources, and unless it explicitly lets go, it can take them back at any time.
Yeah, that is the core tension we are unpacking. The question is, does holding a certificate of title truly guarantee ownership? Or does the state hold a trump card that can invalidate property rights whenever it realizes a mistake was made?
I will be arguing for the sanctity of the Torrens title, because if we cannot trust the piece of paper, the entire real estate market and the security of every homeowner collapses.
Right. And I will be arguing from the perspective of state sovereignty and the Regalian Doctrine. My position is uncomfortable, I'll admit, but it's necessary. You cannot register what cannot be owned. If the land is part of the public domain, forests, rivers, mineral lands, a title is void ab initio. It is dead on arrival, regardless of how much you paid or how long you have lived there. The state's right to preserve the nation's patrimony is paramount.
Let's start with the ideal then, the way the system is supposed to work. The law wants property owners to be able to rest secure in their title. That isn't just a figure of speech. That is the actual phrase used in jurisprudence. The Torrens system was designed specifically to stop the need to look behind the curtain. If I hold the certificate, I am the owner against the whole world. We see this principle codified in the rule regarding double titles.
Ah, you are referring to the doctrine in Gatyawan versus Gapode.
Exactly. It is a classic problem. Through some bureaucratic error, two different people end up with a certificate of title covering the exact same plot of land. Who wins? The Supreme Court laid down a hard, bright-line rule. The earlier date prevails. The first in time is the stronger in right.
And that makes perfect sense for stability between two private people, but it goes beyond just stability. The court was very specific in Gatyawan. They said that the holder of the second, later certificate has no business harassing the first holder. They should go back to the person who sold them the bad title and sue them. The law protects the first registrant from being, as the court vividly put it, molested. It protects their peace of mind. If we start poking holes in the finality of a decree of registration, we undermine the very concept of private ownership. I don't dispute the first-in-time rule when we are talking about two private individuals fighting over a lot that is actually capable of being owned. But you are starting from the assumption that the land can be registered in the first place. My argument cuts much deeper. The first-in-time rule is completely irrelevant if the land belongs to the state. You can be the first person in history to get a title to a patch of forest, but that title is void. It's not a title, it's a hallucination.
But surely the issuance of the title itself acts as proof that the land was alienable. I mean, the government issued it after all. If the court adjudicated it and the Register of Deeds printed it, isn't that proof the state released the land?
You would think so, but legally no. We have to look at the maxim delegata potestas non potest delegari. What has been delegated cannot be further delegated. The Constitution and Congress gave the power to classify land, to decide what is forest, what is mineral, and what is alienable farmland to the executive branch, specifically the President and the Department of Environment and Natural Resources, or DNR. They did not give that power to the courts.
So a judge cannot decide the nature of the land?
Correct. This was entirely settled in Federation of Corone v. Secretary of DNR. It established that courts cannot adjudicate land into private ownership just because it looks like a farm or has a house on it. A judge can't look at a mangrove swamp and say, well, someone built a resort there, so let's give them a title. If the executive hasn't explicitly released that land as alienable and disposable, the court has no jurisdiction to issue a title. If they do, the title is void.
Look, I understand the separation of powers argument, but we cannot ignore that historically, the courts were much more lenient to help citizens. In the early 20th century, we had cases like Ankron and Ramos. Those cases established a presumption that land was agricultural unless the government proved otherwise. It felt like the system wanted people to own land. It placed the burden on the state to say, stop, that's ours.
That was a completely different time with a different population density and, frankly, a different constitution. The presumption has completely flipped since then. Today, under the strict application of the Regalian Doctrine, the presumption is that all land belongs to the state. The burden is now entirely on you, the applicant, to prove it has been released. If you can't produce the administrative order or the proclamation, the law assumes that land is a forest or a mineral reserve. And as we know, you cannot own a forest.
That shift in presumption is exactly what scares investors. It creates a hurdle that is almost impossible to clear without massive resources. But let's look at where the door is arguably open, even in your strict view. Let's talk about patrimonial property.
I'm listening.
Even under the Regalian framework, the state holds property in two capacities: public dominion, which is for public use, and patrimonial property, which the state owns like a private landlord. The Civil Code is explicit that ownership of patrimonial property can be acquired by prescription. That means if I occupy it long enough, I become the owner.
Right. Prescription is a valid mode of acquiring ownership, yes.
And the timelines are clear: 10 years with good faith and a just title, or 30 years of uninterrupted adverse possession if I don't have a title. This is the pathway for the common person who has been tilling the land for generations. If I have been on a plot of land for 40 years, paying taxes, and the state hasn't stopped me, surely that land becomes mine.
It is a pathway. Yes, but it is much, much narrower than you are suggesting. This is where most people get trapped. They confuse alienable and disposable land with patrimonial property. They are not the same thing at all. And the case of heirs of Malabanan slammed this door shut for many people.
Malabanan is a very controversial ruling, effectively making it harder for the poor to title land.
Controversial or not, it is the doctrine we are dealing with. Here is the nuance that trips everyone up. For land to be acquired by prescription, that 10 or 30-year rule you mentioned, it is not enough for the DNR to simply classify the land as alienable and disposable. That classification just means the state has the authority to sell it. It removes the barrier, but it doesn't transfer the right.
So what else is needed then?
Manifestation that the property is no longer needed for public service. That is the kill switch. Without that specific declaration converting it to patrimonial property, the land remains part of the public domain. The clock for prescription never starts ticking. You could live there for 50 years thinking you are earning your ownership, but legally, you are just squatting on government land because the state never explicitly said, we don't need this anymore.
That is an incredibly high bar. It essentially requires a specific law or proclamation for every specific plot of land to convert it to patrimonial property. It turns the alienable and disposable classification into a half measure. It tells the citizen, this land can be sold, but then says, but you can't acquire it by possession until we say we don't need it. It feels like a trap designed to keep land in the hands of the state.
It's not a trap. It's a safeguard for national wealth. Why should the state lose ownership just because it sat on a property for a few decades? The state shouldn't lose land by negligence. We are talking about the resources of the entire Filipino people. Just because a mayor or a bureaucrat forgot to evict you doesn't mean you own the land.
But at some point, the negligence of the state becomes the burden of the citizen. Let's pivot to the physical reality of the titles. You argue that the nature of the land overrides the paper. But what happens when the paper includes things that are naturally public?
You mean like a title that accidentally includes a river or a creek?
Right. If I have a Torrens title that covers 5 hectares and a stream runs through it, the indefeasibility of my title should cover that stream. The boundaries are fixed in the decree. The surveyor measured it. The court approved it. It's mine.
Indefeasibility is a legal concept, not a magical power. It cannot transmute water into dry land. We have to look at Republic versus Siasan. In that case, a title was issued. On the face of it, it was valid. But the court found that part of the lot formed the bed of a navigable stream.
And the result?
The title over the stream was void. Rivers are outside the commerce of man. You cannot own a flowing river just because a surveyor drew a line around it. The public character of the water outweighs the private character of the title. The court basically said the title is just paper, but the river is reality.
I can concede on navigable rivers. That is somewhat intuitive. But let's look at something hidden. Mineral lands. This is where the Regalian Doctrine feels predatory. You have a farmer who gets a title for agricultural land. He farms it. Then, 10 years later, copper or gold is found underneath.
The law is categorical here. Land cannot be half agricultural and half mineral.
But he has a title. He owns the land from the heavens to the center of the earth, right?
Not in this jurisdiction. The title is for the surface rights explicitly. If the land is reclassified as mineral land, or if it was mineral land all along and nobody knew it, the state has the right to extract those resources. The Supreme Court has stated that this is for the benefit of the state. The private owner cannot extract the minerals without permission because, under the Regalian Doctrine, the minerals never belonged to him in the first place.
It essentially reduces the landowner to a surface tenant. It implies that all private property is provisional, pending the state's decision to mine it. But let's look at the opposite of nature. Let's look at land that is 100% man-made, reclaimed lands.
Ah, the Manila Bay projects.
Exactly. The Public Estates Authority, now the PRA, creates land from the sea. Surely, once that land is physically created, it is alienable. It was made for commerce. It's not a forest. It's not a watershed. It is concrete and sand put there for buildings.
You would think so logically. It's not a natural resource. But the ruling on the Manila Bay reclamation, specifically the 592 hectares involving the PEA, tells a very different story. The court held that reclaimed lands are sui generis. They are a class of their own.
Meaning they don't automatically fit into public or private.
Meaning they start as public. Just because the government reclaimed it doesn't make it private. It remains part of the inalienable public domain until, again, two things happen. One, it must be classified as alienable and disposable, and two, declared not needed for public service. Until those official acts happen, those reclaimed islands are legally the same as the ocean. They are outside the commerce of men.
This brings us back to the bottleneck. We create land for development, but legal technicalities keep it frozen. But I want to address the biggest threat to the stability of the system. We've talked about classification, but let's talk about the mechanism the state uses to destroy titles. Reversion.
It's not destroying titles, it's correcting mistakes. The state has the right to recover what was illegally taken.
But the power of the Office of the Solicitor General, the OSG, to file for reversion is described as imprescriptible. That means there is no statute of limitations. If a title was issued in 1950, and the OSG decides in 2026 that the land was actually forest land back then, they can sue to cancel the title. That hangs like a sword of Damocles over every property owner. You can never truly relax.
It is necessary. If a title was acquired through fraud, say the applicant lied about the land being agricultural when it was actually a watershed, why should the lapse of time protect that fraud? The state is protecting the public interest. If we put a time limit on reversion, we are basically saying that if you can hide your theft for 30 years, you get to keep the stolen goods.
Because at some point, the market needs certainty. And this is where the innocent purchaser for value defense comes in. This is the bedrock of the Torrens system. I might concede that the original applicant who lied should lose the title. But if that applicant sells the land to me and I know nothing about the fraud and I pay good money for it, the law protects me. The state's right to reversion should stop at my doorstep.
That is the general rule, yes. The innocent purchaser for value is a strong defense, but looking at the source material, there is a massive caveat that most buyers completely ignore. In a reversion case, the ordinary presumption of good faith is not enough.
What do you mean? Usually the law presumes everyone acts in good faith unless proven otherwise.
Not here. When the state claims the land is part of the inalienable public domain, the burden shifts. The purchaser has to prove they were innocent. They have to prove they exercised due diligence. It's not enough to say, I looked at the title and it was clean.
So they have to prove a negative? That they didn't know about the fraud?
They have to prove they went beyond the certificate. Did you inspect the land? Did you check the status with the DNR? Did you ask the neighbors? If you just relied on the paper, the court might say you were not diligent enough.
That shifts the burden unfairly. You are asking a private citizen to out-litigate the government. The OSG has the resources of the entire bureaucracy. If I have to prove my innocence rather than the state proving my guilt, the title loses its value as conclusive evidence. It becomes just a starting point for an investigation.
But consider the alternative. If we allow the innocent purchaser defense to be absolute, it becomes a laundry service for land grabbing. Someone fraudulently titles a forest, sells it to a dummy who claims to be innocent, and suddenly the state has lost a national park forever. The strictness is there to prevent the Torrens system from becoming a tool for theft.
And I would argue the strictness turns the Torrens system into a trap for the honest buyer. If the government's own agency, the Land Registration Authority, issues a title, the government should be stopped from questioning it later. Estoppel should apply. If you made the mistake, you pay for it, not the citizen. If the state's agent messed up, the state should bear the loss, not the person who trusted the state's document.
But the government is not a normal party. It represents the people. Estoppel rarely lies against the state, especially when dealing with the public domain. The negligence of a few officials shouldn't cost the entire nation its resources. The public domain is held in trust for future generations. You cannot estop the future because of a mistake in the past.
We are at an impasse, but it's a revealing one. The system is designed to provide stability, the first-in-time rule, the protection of innocent purchasers, the pathways of prescription. These are all mechanisms to allow the economy to function and for people to have homes. But you're saying that underneath all of that, the classification of the land is the only thing that matters.
That is the reality. The Torrens title is the result of a right, not the source. If the source, the land classification, is flawed, the title is void. Whether it is a military reservation like Fort Andres Bonifacio, a forest, or a submerged area in Manila Bay, the rule is absolute. If the executive hasn't explicitly released it, no amount of possession, no amount of money, and no paper title can defeat the state's ownership.
Which leaves our listeners with a very practical, if somewhat unsettling takeaway. Do not just rely on the certificate of title. The paper is important, but the history of the land, the alienable and disposable status, the patrimonial declaration is where the real risk lies.
Absolutely. Diligence isn't just checking the Register of Deeds, it's checking the land itself and its classification history with the DENR. A title is powerful, but the state is paramount.
A sobering thought for every property owner. That brings us to the end of this session. We've peeled back the layers of the Torrens system to reveal the bedrock of the Regalian Doctrine beneath it.
It's a complex relationship, but understanding it is the only way to truly secure your property. There is certainly a lot more to explore in these legal doctrines.
Thank you for joining the debate.
Thank you.
Whose function is it to classify public lands, and who in particular exercises the power to classify lands of the public domain?
It is not the court which determines the classification of lands of the public domain into agricultural, forest, or mineral, but the executive branch of the government through the office of the president. Nevertheless, as pointed out in Federation of Coron et al. Versus Secretary of DNR et al., both the president and the DNR secretary cannot delegate their discretionary power to classify lands as alienable and disposable, as the same is merely delegated to them under Commonwealth Act number 141 and Presidential Decree number 705 respectively. Delegata potestas non potes delegari. What has once been delegated by Congress can no longer be further delegated or redelegated by the original delegate to another. Thus, the state through the legislature enacting Act number 2874 4 and Commonwealth Act number 141 delegated to the executive branch the power to classify lands of public domain and finally removed from the courts the power to classify such. Accordingly, the presumption of agricultural classification under Ancron and Ramos cases applied by the courts was also set aside. Indeed, under the Regalian Doctrine, all lands of the public domain belong to the state, which is the source of any asserted right to any ownership of land. All lands not appearing to be clearly within private ownership are presumed to belong to the state. Accordingly, public lands not shown to have been reclassified or released as alienable agricultural lands or alienated to a private person by the state remain part of the inalienable public domain.
Discuss the rules for resolving controversies involving successive registration of the same parcel of land in the name of different persons.
Lands already registered under the Torrens system are non-registerable. A land registration court is without jurisdiction to decree again the registration of land already registered in an earlier registration case. A second decree entered for the same land is null and void. According to Gatyawan versus Gafud, the Supreme Court has laid the rule that where two certificates of titles are found to have been issued to two different persons covering the same parcel of land in whole or in part, the earlier in date must prevail as between the parties, and in case of successive registrations where more than one certificate is issued over the land, the person holding under the prior certificate is entitled to the land as against the person who rely on the second certificate. The purchaser from the owner of the latter certificate and his successors should resort to his vendor for redress rather than molest the holder of the first certificate and his successors, who should be permitted to rest secure in their title. The Supreme Court has held in Realty Sales Enterprise versus Intermediate Appellate Court that in this jurisdiction it is settled that the general rule is that in the case of two certificates of title purporting to include the same land, the earlier in date prevails. In successive registrations where more than one certificate is issued in respect of a particular estate or interest in land, the person claiming under the prior certificate is entitled to the estate or interest, and that person is deemed to hold under the prior certificate who is the holder of or whose claim is derived directly or indirectly from the person who was the holder of the earliest certificate issued in respect thereof.
What is the legal effect of including streets and highways in a certificate of title?
Streets or public highways are non-registerable. The inclusion of public highways in a certificate of title does not thereby necessarily give the holder of such certificate the said public highways. The appellant therefore, even though a part of said street has been included in the original certificate of title and in the subsequent transfer certificate of title, did not become the owner of the said lots.
May the beds of rivers or navigable streams be registered under the Torrens system? What follows if a free patent and a certificate of title were issued over such lands?
The bed of navigable streams, creeks, or rivers are non-registerable. The ownership of a navigable stream or of the bed thereof is not subject to acquisitive prescription. While it may be true that an applicant for a pre-patent was able to get her pre-patent application approved and to secure the corresponding certificate of title pursuant thereto, and said title covered the sapang kabay. Nonetheless, said title did not change the public character of the sapang kabay, the same being covered by one of the exceptions mentioned in section 39 of Act number 496. In Republic versus Shoson et al., the Supreme Court has ruled that if it is true that the lot in question is or forms part of the bed of a navigable stream, creek, or river, the decree and title issued over it in the name of the registrant would not give them any right or title to it. Navigable rivers cannot be appropriated and registered.
What is the legal effect of the inclusion of beaches foreshore areas, navigable waters, or portions of the territorial sea in a certificate of title?
In Republic versus Ayala y Compañía, it was found that the areas in dispute were portions of the foreshore beach or of the navigable water itself. It is an elementary principle of law that said areas not being capable of registration, their inclusion in a certificate of title does not convert the same into properties of private ownership or confer title on the registrant. Where the lots covered by a transfer certificate of title issued in the name of defendants were found to be portions of the foreshore or of the territorial waters, it is not an error for the court to render a judgment against the defendants and to order the reversion of said properties to the public domain. The incontestable and indefeasible character of a Torrens certificate of title does not operate when the land thus covered is not capable of registration. If the areas enclosed and converted into fish ponds were really part of foreshore, such areas are non-registerable.
Are lakeshore lands, like foreshore areas, also non-registerable?
Lakeshore lands or lands adjacent to the lake must be differentiated from foreshore land or that part of the land adjacent to the sea which is alternately covered and left dry by the ordinary flow of the tides. Such distinction draws importance from the fact that accretion on the bank of a lake like the Laguna de Bay belong to the owners of the estate to which they have been added, while accretion on a sea bank still belongs to the public domain and is not available for private ownership until formally declared by the government to be no longer needed for public use.
What is the legal status of reclaimed lands from the point of view of registrability under the Torrens system?
Reclaimed lands are registrable but cannot be conveyed until classified as alienable or disposable lands, open to disposition and declared no longer needed for public service. The Regalian Doctrine is deeply implanted in our legal system. Foreshore and submerged areas form part of the public domain and are inalienable. Lands reclaimed from foreshore and submerged areas also form part of the public domain and are also inalienable unless converted pursuant to law into alienable or disposable lands of the public domain. Historically, lands reclaimed by the government are sui generis, not available for sale to private parties, unlike other alienable public lands. Reclaimed lands retain their inherent potential as areas for public use or public service. The 592.15 hectares of submerged areas of Manila Bay remain inalienable natural resources of the public domain until classified as alienable or disposable lands, open to disposition and declared no longer needed for public service. The government can make such classification and declaration only after the Public Estate Authority has reclaimed these submerged areas. Only then can these lands qualify as agricultural lands of the public domain, which are the only natural resources the government can alienate. In their present state, the 592.15 hectares of submerged areas are inalienable and outside the commerce of man.
Are forest lands, forest reserves or timberlands susceptible to private appropriation and registration under the Torrens system?
Forest lands, reserves or timberlands are non-registrable. Possession of forest lands, however long, cannot ripen into private ownership.
Should lands bereft of forest cover be considered converted into agricultural lands?
The argument that only those lands with trees and timber should be considered as forest land and the rest should be considered as public agricultural land fails because even if an island or a parcel of land has already been stripped of its forest cover, it does not negate its character as public forest. Forests, in the context of both the Public Land Act and the Constitution classifying lands of the public domain into agricultural mineral, forest or timber, mineral lands and national parks do not necessarily refer to large tracts of wooded land or expanses covered by dense growths of trees and underbrushes.
Where public land has been declared a forest reserve and then, as a national park, when may it become subject to private appropriation?
The land in question was proclaimed part of a forest reserve by virtue of Proclamation number 42, dated October 14, 1921. This proclamation was superseded by Proclamation number 716, dated May 26, 1941, establishing the Mounts Banahaw San Cristobal National Park forest lands or forest reserves are not capable of private appropriation, and possession thereof, however long, cannot convert them into private property unless such lands are reclassified and considered disposable and alienable by the Director of Forestry. In this case, there is no proof of reclassification or declaration by the Director of Forestry that the land in question is alienable and disposable.
Discuss the legal status of National Integrated Protected Areas from the standpoint of registrability under the Torrens system.
Areas classified as National Integrated Protected Areas, NIPAs, are non-registrable. The policy of the state to secure for the Filipino people of present and future generations the perpetual existence of all native plants and animals has led to the establishment of a comprehensive system of integrated protected areas within the classification of national parks as provided in the Constitution.
Are military reservations non-registrable under the Torrens system? If so, how may lands so reserved be released from such classification?
Military reservations are non-registrable. If the allegation that the land in question was inside the military reservation at the time it was claimed is true, then it cannot be the object of any cadastral proceeding, nor can it be the object of reopening under Republic Act number 931. A land that is classified as a military reservation zone until reclassified or released from the said classification remains inalienable public land. The lands in the Fort Andres Bonifacio Military Reservation are inalienable and cannot be disposed of by sale or other modes of transfer.
What is the legal status of unclassified lands of the public domain?
When a land of public domain is unclassified, it cannot be released and rendered open for private disposition pursuant to the Regalian Doctrine, and that the private applicant in a land registration case has the burden of proof to overcome state ownership of the lands of the public domain. All unclassified lands are non-registrable. When the property is still unclassified, whatever possession the applicants may have had, and however long, it still cannot ripen into private ownership. Even if the subject lands are unclassified, these are still not subject to private ownership. While it is true that the land classification map does not categorically state that the islands are public forests, the fact that they were unclassified lands leads to the same result. In the absence of the classification as mineral or timber land, the land remains unclassified land until released and rendered open to disposition. This according to Justice Hesmundo in the case of Federation of Coron et al. Versus Secretary of the Department of Environment and Natural Resources.
When may private ownership of patrimonial property of the state be acquired by prescription?
Patrimonial property of the state not yet declared or manifested as no longer needed for public use or the development of national wealth are likewise non-registrable. In complying with Section 14, second paragraph of the Property Registration Decree, consider that under the Civil Code, prescription is recognized as a mode of acquiring ownership of patrimonial property. However, public domain lands become only patrimonial property, not only with the declaration that these are alienable or disposable. There must also be an express government manifestation that the property property is already patrimonial or no longer retained for public service or the development of national wealth under Article 422 of the Civil Code. And only when the property has become patrimonial can the prescriptive period for the acquisition of property of the public domain begin to run. This according to Justice Tinga in the Heirs of Malabanan versus Republic. Patrimonial property is private property of the government. The person who acquires ownership of patrimonial property by prescription under the Civil Code is entitled to secure registration thereof. There are two kinds of prescription by which patrimonial property may be acquired. One ordinary and other extraordinary. Under ordinary acquisitive prescription, a person acquires ownership of a patrimonial property through possession for at least 10 years in good faith and with just title. Under extraordinary acquisitive prescription, a person's uninterrupted adverse possession of patrimonial property for at least 30 years, regardless of good faith or just title, ripens into ownership. Neither can petitioners properly invoke Section 14, second paragraph of the Property Registration Decree as basis for registration where the subject property was declared as alienable or disposable in 1982, but there is no competent evidence that it is no longer needed for public use or service or for the development of national wealth, conformably with Article 422 of the Civil Code. The classification of the subject property as alienable and disposable land of the public domain does not change its status as property of public dominion under Article 420, second paragraph of the Civil Code. Thus, it is insusceptible to acquisition by prescription.
How may the non-registerable status of mineral lands be established?
Mineral lands are likewise non-registerable. Once minerals are discovered in the land, whatever the use to which it is being devoted at that time, such use may be discontinued by the state to enable it to extract the minerals therein in the exercise of its sovereign prerogative. The land is thus converted to mineral land and may not be used by any private party, including the registered owner thereof, for any other purpose that will impede the mining operation. Rights over land are indivisible. The land itself cannot be half agricultural and half mineral. The classification must be categorical. The land must be either completely mineral or completely agricultural. In the instant case, the Supreme Court observed that the land which was originally classified as forest land ceased to be so and became mineral, and completely mineral once the mineral claims were perfected. As long as mining operations were being undertaken thereon or underneath, it did not cease to be so and become agricultural, even if only partly so, because it was enclosed with a fence and was cultivated by those who were unlawfully occupying the surface. This is merely an application of the Regalian Doctrine, which, as its name implies, is intended for the benefit of the state and not of private persons. The rule simply reserves to the state all minerals that may be found in public and even private land devoted to agricultural, industrial, commercial, residential, or for any purpose other than mining. Thus, if a person is the owner of agricultural land in which minerals are discovered, his ownership of such land does not give him the right to extract or utilize the said minerals without the permission of the state to which such minerals belong.
What are reversion proceedings?
Reversion proceeding is the manner through which the state seeks to revert land to the mass of the public domain. It is proper when public land is fraudulently awarded and disposed of in favor of private individuals or corporations, or when a person obtains a title under the Public Land Act, which includes, by oversight, lands which cannot be registered under the Torrens system as they form part of the public domain. A reversion suit seeks to nullify a void title. A void title does not enjoy indefeasibility under the Torrens system, notwithstanding the fact that the original certificate of title based on a patent has been cancelled and another certificate of title issued in the names of the grantee's heirs. A void title may still be reverted back to the state.
May the state be barred from instituting reversion proceedings to recover non-registerable properties of the public domain.
The state has an imprescriptible right to cause the reversion of a piece of property belonging to the public domain if title has been acquired through fraudulent means.
Who may file a complaint for reversion in behalf of the Republic?
Under Section 101 of Commonwealth Act Number 141, the Public Land Act, it is the office of the Solicitor General alone which may file a complaint for reversion of property in behalf of the Republic.
With the recommendation of the Lands Management Bureau or of the Department of Environment and Natural Resources be necessary to guide the Office of the Solicitor General in deciding whether or not to institute reversion proceedings?
Indeed, the nature of reversion proceedings puts the onus probandi on the state in order to ensure that the state would be able to discharge this burden. The Lands Management Bureau or the DNR first determines whether there is ground to file a case for reversion and whether the state has sufficient evidence to prove its claim. Without a recommendation and evidentiary documentation from the Lands Management Bureau and the Department of Environment and Natural Resources, the Office of the Solicitor General could not possibly prosecute its case for reversion. It would not be able to discharge its burden of proof.
Other than in cases where title is acquired over non-registerable properties of the public domain, would reversion proceedings be also available to recover lands covered by patents or grants issued by reason of fraud or oversight?
If a person obtains a title under the Public Land Act, which includes by oversight lands which cannot be registered under the Torrens system, or when the Director of Lands did not have jurisdiction over the same because it is a public domain, the grantee does not, by virtue of the said certificate of title alone, become the owner of the land or property legally included. Otherwise stated, property of the public domain is incapable of registration and its inclusion in a title nullifies that title. However, even if the original grantee of a patent and title has obtained the same through fraud, reversion will no longer prosper where the land has become private land and the fraudulent acquisition cannot affect the titles of innocent purchasers for value. It should be noted that the party who claims the status of an innocent purchaser for value has the burden of proving such assertion, and the invocation of the ordinary presumption of good faith, that is, that everyone is presumed to act in good faith, is not enough. To be sure, proof of good faith is, as it should be, required of the party asserting it. The determination of whether the respondents are indeed innocent purchasers for value can only proceed from a factual inquiry to be conducted by the regional trial court. Without evidence proving that they are indeed innocent purchasers for value, laches cannot be applied to bar the Republic from pursuing the present reversion case against them.